go ahead and call the committee to order. This is the House Judiciary Non-Civil Committee meeting. We've got a few bills on our calendar today. We have, we'll start off with SB 382, which is a holdover from last meeting. I know there were some issues that arose and some drafting cleanup that needed to be done. Representative Atwood has graciously offered to walk us through the changes on the substitute to SB 382. Let's just make sure we have it here and we're all looking at the same. Do we have that substitute in the folder?
We do. You want me to go up here or
But I mean, whatever you're comfortable with is fine.
It should be LC 296025S.
6025S. Does everybody have that? I'm going to assume yes. Okay.
It is
Atwood.
in the folder. And essentially, Mr. Chairman, I think everybody will probably remember from the last time, it accomplishes several things. It corrects a loophole, frankly, in the law, and will allow us to prosecute the middlemen in shoplifting cases, essentially to make it a criminal offense to use a false or a fictitious name or address for the purpose of obtaining or attempting to obtain a refund from a retail establishment. We'll also make it a criminal offense to use a driver's license not issued to a person, a driver's license containing false information, identification card containing false information, an altered identification card to attempt to obtain a refund from a retail establishment. And what we did, and Mr. Chairman, I thank you for your help also in this, is we, along with Ms. Travis, simplified the bill. We had various stages, and as the committee can look, especially at line, let me get my handiwork here. A person who violates subsection A on line 25 shall be guilty of a refund fraud, and it takes it to, and in keeping with the Criminal Justice Reform Act that we did a number of years ago, that below $500, misdemeanor above $500 is a felony, and then it takes us through various iterations and upping the penalty if you in fact or do a shoplifting ring is doing this thing over a period of a 7-day period and that sort of thing, making it more egregious, as you can read, for the person who or people who tend to do this. So that's essentially the changes. I'll be happy to answer any specific questions, Mr. Chairman, if there are any from the committee.
Questions for the author or the sponsor from members of the committee? Seeing none, I know this version came out rather late. It's LC 296025S of SB 382, and because of that, I'll go ahead and ask if any interested parties have any comments on that. Mr. Spehouse, on that, is your community comfortable with? Thank you. Anyone else? Judge Roger Lane is here with us from Brunswick. Welcome.
The judges are comfortable with the concerns raised by Judge McGeary with being satisfied with the substitute.
Great, thank you so much. Any questions from members of the committee to either Mr. Spehouse or Judge Lane for clarification? Seeing none, what's the pleasure of the committee? Mr. Strickland moves due pass of SB 382 by substitute LC 296025S. Is there a second? Second by Ms. Ballinger. Are there any amendments? Seeing none, any further discussion? Seeing none, all in favor, gentlemen's motion, signify by saying aye. Opposed? The ayes have it. The motion's adopted. Thank you, Mr. Atwood, for your hard work on it. Let me call SB 187, which is the shell of the bill is Senator Hill's bill. He has graciously given permission for his bill to be used by Chairman Willard so that HB 797 could be used as a vehicle for that language that was in 797. I know there had been some conversation, I think, running up until subcommittee, but there may have been some back and forth, and I think a lot of confluence of events and a lot of things happening at once. So we're glad that we can be able to use 187 as that vehicle and appreciate Senator Hill doing that. With that, I'll ask Chairman Willard if he'd like to. My apology for any disparagement that may. Chairman Willard.
All right, I'll sit here if it's all right, Mr.
Sure,
Chairman.
absolutely.
You're right. We had a bill that was in your committee as a House bill, which was 797 through various things going on toward the last minute. We did not get it out of the subcommittee to full committee, and it's a good bill. It's a bill that deals with some issues that address the Criminal Justice Coordinating Council and some suggestions that were made by the Women's Policy Group wanting to have some clarity in the language. And although you have some areas, let me just talk about it briefly, you have some areas that are underlined, like you start in paragraph A. This is not really new language. It is, we'll call it improved language. But if you look down further in the bill, you'll see at lines 43, 44, 45, 6, and 7 is basically the same thing. So you're not creating a new cause of action for someone who was in this state, injured in this state as a result of a criminal conduct, but may have been a resident in another state. They still have the right under the current law, as they will with the new bill that we're passing.
Mr. Chairman, let me just interrupt. We are looking at the substitute, and I should have said this earlier,
yes.
LC 296032 ERS.
You're correct. That's the one we're talking about, which is addressed as Senate Bill 187. Working with the policy group, but then also very much so with Ms. Travis, we have made some relocation of language, changed a little bit of language, but the intent is still there as far as the current law that we have. The one other thing that we did do was change the statute of limitations for the right to bring a cause of action of 3 years, and that is after the person has reached their 18th birthday. So there is a right for a person to receive a compensation through a claim filed with CJCC up to 3 years after the occurrence or after the death of a person. That is on lines 135 through 140. The other part, it is again looking at section 17-15.7 on page 6. This is again language that is replaced from other parts of the current law, and also taking, as I recall, Ms. Travis, some language that is out of the federal statute that addresses the standards by which it is to be gauged if a person is right to compensation through CJCC. So those are really the main points of it. The rest of it is I'd say, some clearing up language as you go through the bill. It's just where we had sometimes all other claimants just dressed as claimant. We kept the victim term in there that was requested by CJCC, and we took out on page 11 a provision under 17.15.9 and have a new provision 17.15.9 and a new provision 17.15.10, which is just recognizing the there's not to be addressed by any contrary language application of this law. This will be the provisions to apply. With that, Mr. Chairman, I will be glad to respond to any questions. I think there's a couple of people who would like to also address the committee on the bill.
Mr. Chairman, in what I understand we're doing is we're expanding the universe of individuals who can apply under the law. Is that a correct statement?
I don't think it's so much expanding the class of persons. I say it's clarified some language that deals with who are potential victims and claimants that can seek recovery. As I mentioned on the second page, looking at the language we have under lines 22 down through 28, that is really describing under what circumstances a person may be considered a victim, and that's really clarifying language that you see down further that we've relocated in the bill in the statute, which is starting at lines 43 through 47. So I think the basic premise of who has a right to file as a claimant stays much the same. It does improve the language and also sets up that 3-year statute of limitations, which extends it somewhat for an individual.
Your comment earlier about are we not so much complying with a federal mandate, but I think you said we're tracking federal language on that?
We are. That's what Ms. Travis went to the federal laws dealing with this issue to be sure that as we had definitions, we were tracking their language for it.
And just to be absolutely clear, what is it about the federal law that we are now adding in that we don't otherwise have in the state law?
Okay. I think you look over on page 6. Pardon me? Page 2 also. Why don't you get Ms. Travis, why don't you, if you would address that for us?
If you look at line 33, where it says or a violent crime is defined by state or federal law, which
Yeah.
results in physical injury. First of all, we don't have violent crime defined in state law. We do have violent crime defined in federal law, and the definition of violent crime in federal law is found on lines 37 through 41. This word here is the definition of the word crime. So sometimes when a crime is committed, there is a result of that crime, which is injury, and that injury then moves to where we talk about what happens to the claimant, as opposed to being within the definition of the word crime. So the only federal law that has been brought forward is line 37 to 41. And then earlier, in the draft version of this bill, it had the USC site, 18 USC 16, I think that's the citation. And it spelled it out so it makes it easier for the reader to understand rather than have a redundant.
And just to be clear, it's an application for a claim. There's no,
Exactly.
it's not as a matter of right. There's a
No,
process
it has to be reviewed and approved by
and so forth.
CJCC.
Is it current state law that an individual who is not the actual victim of a crime can make application for a claim?
Yes.
Okay.
Victims, you could have someone who's a parent apply for the child who's the victim, and so they would be the claimant, but then the person who's been actually injured is the victim.
Okay. So we're not plowing new ground there?
No, sir.
Okay. Questions for Chairman Willard? Questions for Chairman Willard from members of the committee? Seeing none, I don't know if we put a sheet. I don't think we put it.
Might I?
Oh, right next to me.
I'll come back. There's a proposed amendment that I'm going to discuss that the district attorneys, prosecuting attorneys council
Okay.
would like to also add to this bill, make it a choo-choo.
Okay. Let's, since we did not have this in subcommittee, we'll go ahead and hear from, we'll have a public hearing portion. I would just ask potential witnesses to please, if you would, keep your comments limited just in the interest of time. We'd appreciate it. And I'll just go in order. Ms. Ann, is it Burgess with the Gwinnett Sexual Assault Center? If you would pull the microphone a little closer to you, thank you.
Is that better?
Sure.
Okay. Thank you for the opportunity to speak to you today on matters of Senate Bill 187, and specifically how this bill will better serve victims and families with improved access to Georgia Victims' Compensation Assistance. I'm going to speak solely and primarily about child sexual abuse and sexual assault victims. However, the language in this bill certainly serves all victims. I'm the director of Gwinnett Sexual Assault and Children's Advocacy Center, where we provide 24/7 services to children, adolescents, and adults that include forensic medical, personal and legal advocacy, family advocacy, and child forensic interviews for children who are sexually or physically abused or may be survivors of parent or sibling homicide. We've served Gwinnett County for 27 years, and last year we served just over 1,800 victims. The individuals and families that we serve suffer physically, psychologically, emotionally, and financially in the aftermath of their crime victimization. Adult victims often experience physical injury, risk of HIV, post-traumatic stress, clinical depression, and other debilitating effects. In addition to the physical and mental impact, victims and families suffer significant financial burdens. Child victims of sexual and physical abuse have often endured long-term chronic abuse, and sadly the abuser is often a parent or a family member. Disclosures are often delayed, as children are most vulnerable to the control, threats, and manipulation of adult abusers. Regardless of age, each victim has unique and distinct needs from the other. Georgia Crime Victim Compensation Assistance is an important lifeline to these victims and to these families, oftentimes life-saving. The current application process of this compensation assistance require that victims prepare and submit layers of information and supporting documentation within 1 year. The process often requires meetings and assistance by advocates and others that aid and assist victims in acquiring the required documentation. This can also require travel to third-party agencies, and that is problematic when victims are experiencing difficulties with transportation, child care, and work schedules that can make this prohibitive. Child victims are dependent upon a parent to represent their interest and complete this application. Many parents are unable to do so in the aftermath of their children being victimized, as they suffer emotional trauma, logistical hardships, and daily responsibilities with limited resources. Sadly, if an application is not submitted for a child victim, it effectively excludes that child from accessing vital medical and mental health resources to aid with their recovery and their healing. This bill tangibly improves a victim's access to these funds by replacing the current 1-year rule for the application with a 3-year provision. It further serves victims by providing consideration for good cause even beyond that 3 years. It, by virtue, acknowledges that victims suffer physical and emotional hardship that often impact their ability to timely comply with administrative requirements under the current 1-year rule. This bill also provides that any child victim has until their 18th birthday to submit a claim for assistance and duly provides for that same good cause beyond. This will assure that victims of child abuse are not effectively excluded from assistance in those cases where a parent did not submit a claim. This bill allows for more inclusivity, and it will improve successful claims by victims of sexual assault and child sexual abuse. It serves all victims with improved access to funds, and that will benefit the health of all Georgia communities. Thank you.
Thank you, Ms. Burgess. Stephanie Woodard, on behalf of the Prosecuting Attorneys Council and the Solicitors General Association.
And I'm going to bring Mr. Spehaus up with me. He was a little slow with his orthotic issue. So
I don't know. I've seen him walking around. He's
well, that was
he's
his story to
adapted
me.
very well.
So, good afternoon. Thank you for letting me have an opportunity to address the prosecuting attorneys. World has added an amendment that I believe are in your folders. I need to do a little renumbering now because there was a new version, asking for forensic interviews to be included in this expansion for CJCC.
Walk us through that.
Forensic interviews are the psychological interviews that children go through. We currently pay for forensic medical exams for children who are there are concerns about abuse or sexual abuse specifically, but also other forms of physical abuse. Historically, forensic psychological interviews were not considered for reimbursement. That was because it was never included in the federal definition. The federal definitions changed some years ago to include that. The forensic interview is by a trained professional psychologically. It's usually a licensed clinical social worker, at least a certified forensic interviewer who is impartial and a neutral party, if not a full psychologist. I'm on the board of RCAC in Hall County. We have 2 PhDs that conduct our forensic interviews. A forensic interview is a neutral fact-finding, one to help explore symptoms that the child may be experiencing that aren't physically present, that there will not be any physical injury to substantiate. There is a recorded interview, recording of the interview. Neither party is there. It's to keep the child from being questioned multiple times in an adversarial or more anxious, anxiety-producing situation. So that the first time the child's information is recorded is not in by a law enforcement officer in a station, in an emergency room, or other traumatic. It's not by a defense attorney or by a prosecutor. It's by a trained professional psychologist. That interview results in information being provided to both sides of the parties that would be involved in litigation and over the alleged acts, if there are any, but also a referral and connectivity to services for the parent. Meaning that if a child who has witnessed the domestic violence homicide of his mother, been injured in any way as a result of that, or has witnessed repetitive violence, if the prosecuting attorney's office is the one saying your child needs counseling, your child needs to see someone for these PTSD type things, that comes cloaked to the parent under the guise of an interested party in that. Likewise with the defense attorney. When the forensic interview mental health professional is saying it, there's much more indication of connectivity to resources for the child to help recover from the crimes that have been done to them or that they've witnessed. The Department of Justice several years ago adjusted their language to include forensic interviews for VOCA funding, and they are now incorporated in the federal definitions. We're asking to go ahead at this opportunity and update Georgia. There are several other states that do. The amendment that we have proposed would actually now be inserted at line 60, adding right before the forensic medical exam the definition of the forensic interview and tracking that out. And I'm sorry, gentlemen and members of the committee, I didn't have an opportunity. Lots was happening on the drive down from Hall County this morning. So there is a little bit of language. Behind the language of technique, the i.e. corner house and other CACs would not be included. But we would say insert this language at line 60, defining what a forensic interview is by the child advocacy, and then lower, inserting at line 466, the language of when a forensic interview is conducted, the cost of the forensic interview shall be paid by the fund with amounts and caps to be determined by the board for CJCC. Historically, we have 42 CACs in the state.
Back up 1 second. Let me ask you to repeat that, because that's not consistent with what we have here.
Yes, sir. What we found, we surveyed all the CACs that are currently in existence in Georgia. The average cost for a forensic interview in Georgia was $310. So originally, that's the language that was put in here to give a benchmark. Further reflection and discussions with the district attorney's office, with the CAC community, giving the board of CJCC the ability to cap that expense if they want to instead begin by not starting at $300, whatever cost. If they wanted to do this is the cap for the forensic interviews that we can do for the year, as well as a cap per in underwriting. So instead of defining that in a monetary amount, then in a couple of years we'd be back before the legislature saying it needs to be adjusted one way or the other, though I doubt it would be.
Well, what is the language that you're proposing?
That with the amounts and caps to be determined by the board of CJCC in lieu of that specific 310.
I need you to read the sentence.
Okay. When a forensic interview is conducted, the cost of such forensic interview shall be paid for by the fund, with amounts and caps to be determined by the board of CJCC. The fund shall be responsible for the payment of such cost.
Let me ask you to read that again slowly so I can make sure that council has that. I also want to make sure that Chairman Willard is comfortable.
At the beginning of that second sentence.
Yes, sir.
Paid by the fund, and then you had what, Ms. Woodward?
With the amount and caps to be determined by the board of CJCC.
Where does the fund turn?
So it would read, shall be paid for by the fund with amounts and caps to be determined by the board of the CJCC. I mean, caps isn't.
Yes, sir. That's what.
How much for the amount to be determined
Yeah.
Okay.
by the board?
Yep.
Is that going to be a case-by-case basis or actually a ceiling amount?
What I would anticipate them doing is a specified amount that they would
I
reimburse
think
on
we
any
need to
forensic
clarify
eye.
that then. We're going to have it that way. It reads to me that be determined on a case by case, would say, and for an amount not to exceed a sum determined by CJCC.
I'm very comfortable with that, Chairman.
In other words, you want to have the flexibility for the board to go ahead and establish a ceiling,
Yes, sir.
a specific ceiling, without it being just open-ended on a case-by-case basis.
Yes, sir.
I think that also gives them speaking as a member of the CJCC board, I think it gives us the flexibility to say there may very well be different categories of interviews, different levels of interview, different
Sure.
expenses that go with it, so we could set that by the board.
Okay. As a preliminary matter, let me just confirm with Chairman Willard that he's comfortable with the amendment
Sure
as,
will be.
as it's been described. Okay.
Sure will
Questions for the prosecutors, either in general or on the amendment? And let me just make sure council's comfortable with the structure.
There's some difficulty with this language. Do we need, like, children advocacy center, all caps? That's not a word that we use in the code that I'm familiar with, would be capitalized. I don't know if the location is something that's necessary for this amendment.
Yeah,
Um,
good point.
the word in subparagraph B, the word forensic interview is being used again, although that's the defined term.
Okay. Let's do this. It'll almost certainly come out under a modified open rule if I had to take a guess. And if it's not, we can make sure that it does. Chairman Willard,
Yes, sir.
I think maybe the thing to do would be to go ahead and just
Inform
take a
them.
motion without the amendment, clean up the amendment, and put it out on the modified open. Does that
That's
sound
fine.
okay?
That's fine.
All right.
But
Is that-
you'll-
Is that discretion the better part of valor on that one?
Absolutely.
Okay. Okay. Thank you very much.
Thank you.
Ms. Donna Brown? Okay. Thank you. Thank you. Ms. Jacqueline Bunn and Stephen Hatfield from the CJCC.
We're also going to bring out Robert Thornton because he's worked with the fund and has some direct information.
That's fine. Let me just ask you again, if you keep your collective comments brief, we'd really appreciate it.
We will.
Thank you.
We will.
Thank you so much for allowing me to speak today. I would say that to begin with, the overarching goal of CJC is to focus on victims. And we just want to be sure with every change that we do to the statute that we're not impeding the ability of victims to be compensated. We had some concerns actually in the way the definition was changed a bit, and would just ask that maybe language that allows the board to have some discretion in determining what an offense is be added. That's under 1715-2, beginning on page 1.
I think that is
Crime means-
I think that is something that I would probably ask you to discuss with the chairman offline,
Okay.
with Chairman Willard offline.
Okay.
And given the fact that we're already operating under a certain substitute, if there were to be additional changes,
Okay.
since, I mean, we don't have any language in front of us either, do we?
No.
Okay.
The only other concerns that we had specifically to the substitute that's here relates to in some places where claimant has replaced victim. And so, for example, on page 7, where it's referring to claimant, it's actually, we think it should be victim because it's referencing.
What line do you mean?
Line 232.
232.
232.
Yeah.
This is a reference to sexual trafficking victims, but it's referencing claimant, and so we just think for clarity, so it's clear that it's the victim of sexual trafficking.
We actually, and this is I know this has been part of the conversation as this bill has been looked at, where there's been change from victim to claimant, and as a literal matter, they're making a claim under the fund. My sense is that personally is that
Yeah.
it doesn't mitigate their status as a victim,
Not a bit.
but
Excuse me, there are some instances where the claimant may not be the victim. So in this situation, it's actually the victim is the victim of human trafficking, not the claimant. In this situation, you would bar any victim who is not the claimant from receiving any benefit under this particular section.
You wanted to make that change, you need to say person, because you have to look at the cross-reference. begins on 9/1/91. So it shall not apply if the person is as defined in.
That would do it.
Say again, counsel, please.
Let's strike the word claimant on line 232 and replace it with the word person.
Is that the only instance?
Is there
I
another
think there
one?
was one other issue. Right, 239. Here, currently in the operation of the victim's compensation statute, we're looking at criminal histories of both the victim and the claimant. Here, if we remove the word victim, we would not pull the criminal history of the victim before making an award. So currently, if the victim has been convicted of a violent felony in the past, they don't receive an award under the statute. Here, with this change, we want to look at the claimant and not the victim. So leaving the word victim or claimant, we continue to operate in this manner.
Yeah.
Let me ask counsel.
That's fine. We've had some discussion offline. I tried to make all the corrections that they asked for.
Mr. Chairman, let's. I'd like us to consider the following. We have the amendment from the prosecutors on the forensic interview. We now have the victim-claimant issue in isolated occasions on in the substitute. What I think I'd like to do is to take less than 24 hours to prepare a new substitute, and what I think the chair is inclined to do would be to call a meeting in the speaker's conference room, given the time and date, tomorrow morning after the prayer.
All right.
To consider a cleaned up substitute at that point. That way we really know and have the confidence that we've
Get that in there.
hit it where we really need to hit it. Is that,
That'll serve the purpose of getting it moving. Yes.
I think it would, and it also would serve the purpose of us not missing anything, because I know we're at a late date. If you miss it,
But we
then
gotta
you're
get
looking at
here
the floor,
Back over now to the
and it goes
Senate.
back over, then you're agreeing as amended, and strange things happen. So we'd like to mitigate that possibility. So I think we'll go ahead and try to do that. So we can count on a hopefully quick meeting after the prayer tomorrow in the speaker's conference room on this bill.
Could we just speak to the amendment that we just learned about?
Sure.
Okay. Related to the forensic interviews, I guess from CJCC's perspective, our only concern is that those interviews are really for prosecution, not necessarily for the benefit of the victim. And historically, the fund has paid for things that directly benefit victims. And that therein is our major concern about that.
For out-of-pocket expenses incurred by the victim, and also we talked with our federal partners, and each claim that we pay currently, we are granted a federal award as 60% of that federal award, and the forensic interviews are not covered under that.
That's a good point. And where's our DAs?
Yes.
You hear what they're saying? That is not covered under CJCC's guidelines for payment.
That's correct. That's why we brought this proposed bill with the, in conjunction with the governor's office. I can list off the states that are currently paying for these out of.
But it's a budget item, I guess, the question.
And that's why we give the board the discretion to make the decision of when they can and at what rate that they would compensate. And the board can make a determination that doesn't have the funds to do it.
And specifically, that's what I was trying to address in discussion. That's a misnomer that it's not solely for prosecution. It's absolutely not the current state of how forensics work.
And I'll add a little bit, with our federal partners, we did ask a question. The VOCA grant, Victims of Crime Act, there's a two-part grant. One is for victims' compensation payments, and they reimburse 60% of the state outlays every year. Is reimbursed by the federal government, and those aren't taxpayer dollars either. Those are federal fines and fees that go into the Crime Victims Fund on the federal level. Those come back to the state and redistribute to victims of crime. The other part of the VOCA grant goes to the victims' assistance. We receive a little over $11 million per year that has been granted out to victim service agencies around the state. And those include CACs, or Child Advocacy Centers. The issue with the VOCA grant is they can't pay for the forensic interview either. For the portion that is for the prosecution purpose, for the portion of the interview that's used to identify services for the victim, we can reimburse that percentage. It's a little difficult to parse that out, but we do allow CACs to get reimbursed for that. Victims of Crime that administers the federal grant, they have issued some new regulations that were out for comment, and they haven't gone through the entire rulemaking process yet. But once they do, they will allow for the federal grant on the sub-grant side that we administer to pay for the entire forensic interview. That's not the compensation piece that we're talking about today. That's on the grants we give out to organizations. They're not giving us more money for that that we've learned about yet. So that would, if we did pay for that, it would come from the current CAC budgets, or we would have to take money from other victim service agencies to give them the funds to pay for those interviews.
Isn't that a proper role of the board, though, to go ahead and make that determination?
Yes, the CJCC's board, when it makes the grant awards, they could decide to give the CAC more money if they deem that necessary, but yes, that would be their role. But it would be taking from other recipients of the grants to
Okay.
give them more money.
I don't know if these are issues that have been brought up with the author when 797 was originally introduced or not, but the bill's been pending for a while.
Yeah.
And so let's go ahead, Mr. Chairman, and proceed on that path to see a nice, fresh, clean
Yep.
substitute that, crosses the T's, and then we'll go ahead and hopefully proceed to a motion at that meeting tomorrow morning.
Please, Ms. Travis, you'd be able to check with her and see what finally there is. These things we have, victim and claimants, get that resolved once and for all.
Is that it?
Yeah.
That's it.
Those are the only other.
That was it.
Okay. I think it needs to be changed to person in one other location, so you're aware.
Okay.
Well, let's hold on that conversation now, since we're going to take it, carry it over for tomorrow morning.
Page 8 on 250.
But we'll
And are we?
let's just make sure we have the substitute really complete.
And am I working in the tax amendment? Or you all need to?
You're talking about the forensic,
Yeah.
that piece? Yeah, I mean, I would work that into the substitute.
As funds are available.
Okay.
I would just
As
ask you
funds are
to
available.
work that into the substitute. My sense is there may be further policy conversation that has to go into the
I think
substitute.
Leave it that way, as funds are available. That way, won't.
My sense is that the author will weigh in as appropriate.
Okay.
Okay, thank you very much.
Thank you.
With that in mind, we'll call Senate Bill 116, Senator Thompson.
Thank you, Mr. Chairman.
Senator Thompson, welcome.
Thank you, Mr. Chairman, members of the committee. This I bring before you, it's a committee substitute or a subcommittee substitute to Senate Bill 116. This was a bill that was heard last year, and it basically, without going into last year's bill, because there were significant changes between last year's bill and this year's bill, and although both deal with vulnerable road users, I think that this is basically a good statute that tries to, or a good bill that, if it becomes a statute, will be in line with what about 17 other states do. So it's not something that's sort of breaking new ground around the nation. To deal with the issue of vulnerable road users, as we're having more and more pedestrians, more and more folks biking, more and more folks using alternative means of transportation, and that we, as a state, are trying to encourage people to do that. We're also having a situation where we've got more vulnerable road users, more pedestrian fatalities. There's been some discussion about the fact that this grew out of a situation that happened in Gwinnett County, but that said, it's a situation that goes on all around the state. I'd be happy to answer any specific questions about the bill that's in front of you, which I'm looking at LC 296024S.
That's what we have. If you could just walk us through the basics of it.
I mean, the basics of this is that it pulls vulnerable road users into one section of the code and basically talks about, when there's one of these other aggravating circumstances, which range from fleeing a scene to DUI to reckless driving, all of these other things, that when you're dealing with a person in one of these areas riding an animal engaged, which could be in farm areas, persons in a crosswalk, persons upon the lawful public right-of-way, skateboard users, roller skaters, pedestrians, inline skaters, so on and so forth, that any person that would be guilty of violating one of these subsections in concurrent would be basically committing this additional offense. There would be a misdemeanor as treated by the courts. I believe that's the gist of it. I may not be as artful as I was in subcommittee. I haven't had enough coffee yet.
It's okay.
Sorry.
Mr. Atwood.
Just one question. Senator, line 23, I have been very quickly trying to pull up a definition of public right-of-way. I think I know it when I see it, but I want to be sure. Maybe Ms. Travis can answer it too. And I couldn't find it.
My understanding, having served on some committees in my county, those are the areas of land along the sides of roads oftentimes, but they're, in my district, we call them goat paths, where folks are walking, but nobody has paved them yet with sidewalks, but they are, in fact, on government property.
But they're not the roadway themselves.
It's not the roadway themselves. You're basically on the
I
shoulder.
assumed that was the case. Just want to be sure.
Yeah, you're basically on the shoulder or the unpaved grassy area next to the shoulder.
Gotcha. Thank you.
Mr. Radley.
Just to Representative Atwood's, I think, isn't it the state right away along where you've got is 3 to 5 feet in?
I believe so, yes.
So there is a designated measurement. I think there is. Okay.
Mr. Ramsey.
Yeah, I think state right away, you'd have to look in the deed records to see. That's where the definition would be for every square inch of state. Yeah, it varies whether it's sometimes they'll condemn a larger slope easement or even condemn it in fee, and it'll be larger. Some areas smaller. So I think you probably won't find a definition per se. You'd literally have to go look at the deed records all over the state to figure out exactly where the right of way is, because it's going to differ depending on the road and the maintenance obligations. Yeah. Yeah. Chairman Thompson, I wasn't in the subcommittee on this discussion, so can you just explain to me, so if one of these vulnerable road users are killed by a car, by a driver in a car, how would their potential charges differ from a person that's killed by somebody engaging the exact same conduct and hits a vehicle, a car? So how would they be treated differently from a charging and potential sentencing standpoint if your law passes?
Sure. I guess I guess it would depend on the nature of a vehicle striking another vehicle, because of course you can have a fatality in a car crash where there's two cars involved, and that may involve, balls can bounce a lot of different ways, but basically everyone's going to get charged, will be punished under 1710.
So if you hit somebody if you're the driver, the offending vehicle engages in exactly the same conduct that leads to the death.
Of course, if they're DUI and they're killing someone, vehicular homicide, hitting another car, there are a lot of other charges involved when you're hitting another car.
Right, but but again, if they're engaged in exactly the same conduct and they hit a person on a bike, and I'm a cyclist, at least before I got into the legislature I was, and versus a person in a car, the driver that hits the bicyclist, there's one of the charges is potentially greater than the person that hits the person in the car.
That's correct, because these are vulnerable road users. A person in a car has the advantages of safety belts and airbags, and the car itself, the car structure itself, depending on the car. You see all those commercials about the crash cages in Volvos and Mercedes. The cycles that you and I have a Raleigh does not have a crash cage. If someone hits me, I'm pretty much toast. I mean, at the same speed that they would have hit if they were to hit me and I were in a Mercedes or in a Volvo or some other vehicle like that. And I think as a policy, I think we need to start looking at if we're going to start encouraging more people, either from a public health standpoint, to be cycling, to be walking, to be jogging, or
take horse-drawn carriages. Right.
Well, I think that's mostly
so basically the goal is to kind of send the message. We want you drivers. We want you paying attention to these vulnerable users that are out on the road, and this is a way to encourage that.
Sure, it's to use the motorcycle rider bumper sticker, look twice, save a life, kind of thing.
Thank you.
But
I'm using
We're
their bumper
essentially
sticker.
assigning a special designation for that particular class of individual,
As 17 other states have done, yeah, as vulnerable road
where the
users.
driver is committing the exact same conduct. It just happens to be.
Because it's inherently more dangerous when you strike someone who's not in a vehicle where you've got all of the federal safety regulations.
But
that
no,
apply to a
I
vehicle.
understand that. It's just that the conduct of the driver's conduct is the exact same. It's just they're finding a different victim. Right?
That's true, yes.
Okay.
Yeah.
Mr. Atwood.
Just to help you understand, I don't normally do property law or anything else. Is there an average, or maybe a member of committee, on the public right-of-way? How far on the average does the public right-of-way go into a roadway? And I'll tell you why I ask this. In my little city there that I represent, there is a wonderful man, but he gets his little electric scooter and he gets out in the middle of the road every morning of his life. And I've counseled him not to do that because I almost ran over him one time and I couldn't see him. And he's a good guy.
Sure, if he's actually in the roadway, then that's something different. This is being in the grassy area alongside the road, and I believe they're probably, at least in Gwinnett County, there's a default of 5 feet in Gwinnett County. I'm only going to tell you what I know. Now, there may be parts of Gwinnett County, and I know that from serving on a SPLOS committee, there's a default of 5 feet. However, there may be, as I think it was either Representative Ramsey or Pack said, depending on whether they bought additional right-of-way or whether there's an easement there because of a power line or because of a bridge or something else, there may be additional right-of-way. There is a minimum, but this isn't being physically on the road. Your constituent may be violating some other laws by being on the road with an unlicensed vehicle. But talk with the folks with their golf carts in Peachtree City and about that. I don't know exactly what's going on, but that's not the same situation.
We have a resident expert on the Peachtree City golf carts right over here.
I warn you about the messing with the golf cart riders.
We're intimately familiar with any issue that may come up that affects golf carts. We've all been indoctrinated
Yes.
in that, and rightly so, I might add.
I'm in judiNon
no kidding.
civil on the other side. So.
No kidding. It's an important thing to remember for all of us. Mr. Ramsey, did you have an answer on the right of way?
Yeah, and I think so. Your question is how
if there's a rough average. I'm on a roadway. I understand off the road. I get that, but in a normal town, a normal city, how far would it go? And would a normal bicyclist riding on the right-hand side of the road, would they be in the roadway, or would they be in a public road?
Well, a bicyclist,
I mean, the right-of-way or the public road?
Operates as a motor vehicle. It has to follow the rules of the road.
That's correct.
And they're in the roadway. They're not on the shoulder or the.
They're not in the right of way. That's the question. They're in the roadway.
I didn't know if
is
it
my
went
understanding
on the average a little bit or not because I didn't see the definition on it.
It's a question of how far in off the sidewalk, if there is a sidewalk, does the right of way extend?
Correct.
That's what I don't know.
I think I get it, Mr. Chairman.
Yeah, I think it would probably be the edge of the solid line right there.
That's my assumption.
Then it starts because the asphalt's going to vary, and then in some areas where there's curbs, it would. I mean, more urban areas. So.
Mr. Strickland.
On the same note, Mr. Chairman, my question is a public right-of-way. While we talk about how far it extends beyond the road, isn't the entire road? Is there a difference between the roadway and the right-of-way itself? Isn't the entire road in an actual legal right-of-way? Do we know if there's a distinction? Which I think, if it is, I think it's fine because we have the word lawfully on line 23. And so if someone is not supposed to be in a road, then they wouldn't be lawfully operating a right-of-way.
If you're jaywalking, which I believe is walking down the middle of the road, then I don't think this applies to that right or wrong because you have to be lawfully in the road and when you're walking in the middle of the road, as happens in my district, that you're not in a crosswalk, you're just utilizing the roadway, which is not necessarily, maybe it's sometimes understandable, but not certainly permissible.
In the code, the roadway is defined as exclusive of the berm or the shoulder. So I don't know if you're interested in making it say operating any of the following on a berm or shoulder crosswalk. Well, we already have shoulders. Right of way is defined for Title 40 in the context of who is a right of way at an intersection, not the right of way, the public right of way next to the
road.
Okay.
So, I don't know.
If I may, Mr. Chairman. Was it your intent to include anyone that, I mean, you have motorcycle. Wasn't it your intent to include someone on the actual road itself as well that's operating legally on the road?
Yeah, because some of these are. Yeah, it's about vulnerable users. You're legally in the road if you're legally in a crosswalk. If you're on a motor scooter, a properly licensed motor scooter or moped, which some of them can be if you're on a motorcycle. So horse-drawn carriages, have a license to usually be on the roadway. I mean, the farm vehicles, when they're on the roadway, are usually, there's permission for them to be on the vehicles in those areas where you have farm vehicles that sometimes get out in the road because they have to use the road to get from point A to point B, whether that's a tractor or what, horses or not.
Right. If I was reading the bill, I would interpret public right-of-way without a definition of that as being the legal road, but it just extends beyond the road, and it varies. I know in my experience, it depends on how old the road is. There's some old right-of-ways that go way out and some that don't. And so it varies from place to place. But I think having the word lawfully there covers us. But I do believe in make sure we are including the actual road itself. That way a tractor is carrying equipment legally down a highway that it can legally be on, or a two-lane road is still covered by this bill, and a motorcycle as well.
Any further questions for the author? Seeing none, we'll take some public testimony.
Do you want me to remain?
We actually took public testimony in subcommittee. I know there are just a few people signed up. We'll go ahead and hear from them if they want to be heard. I would ask them to please go ahead and keep their comments brief, since I've already said that we would. I want to hold to that. Ms. Wooler, did you with Georgia Bikes, did you have comments? Okay. And all right, Ms. Cerna with you're also with Georgia Bikes. Okay. Did you want to offer some testimony?
Do you want me to?
You can come up over here, Ms. Cerna, if you like. And I just ask you to please keep your comments brief, if you would.
Absolutely.
Thank you.
Good afternoon. I'm Rebecca Serna. I'm the board chair of Georgia Bikes. We are a statewide bicycle advocacy organization representing over 36 organizations throughout the state, as well as recreational riding clubs. And we do support this bill. We've been following it fairly closely, and we're very pleased to see this moving forward. We also support other modes of transportation and active recreation, and so the value of having a multimodal bill that addresses the safety and needs of vulnerable users throughout the state in whatever mode they may be traveling is absolutely vital, I think, to our economic well-being and the safety of our state's residents and visitors. So we applaud this step, and we hope that it moves forward.
Thank you very much. Mr. Bob Dallas?
My name is Bob Dallas, and I chair the PEDS board, which is a statewide pedestrian advocacy organization. I'm also the policy advisor for the board of the Southern Bicycle League, another bike organization. And for 8 years, I served as the state's highway safety director. When you combine pedestrians and bicycle deaths in Georgia, that represents about 15% of the crash deaths. We've seen tremendous reductions in other causes and victims of crashes, but bicycle and pedestrians have not seen that same reduction. They've been basically flat or increasing as it relates to pedestrian deaths. And so this bill, we believe, raises the awareness amongst drivers of the consequences of driving in certain fashions around vulnerable road users. And I think to the point that was raised earlier, what's the difference? Well, the driver may be driving the same. Let's say they're speeding through a road. The consequences of when there are just other cars around there is going to be much less to the other potential victims in cars versus if they were driving in a road with a lot of pedestrian or bicyclists or those that they would see. The consequences to those road users is much greater. As we know, they're much more likely to die from that crash as opposed to a person in as an occupant of a vehicle. So that's really what this does, is it raises significantly, I think, the awareness amongst the driving public that the consequences of the driver's behavior is different in different settings. Amongst vulnerable road users, it's a very high consequence. Thank you.
Thank you very much. All right. That I see no one else signed up to speak on SB 116. What's the pleasure of the committee? Is there a motion? Ms. Kendrick moves do pass. Is there a second? The chair will second. Is there, are there any amendments? Seeing none, any further discussion? All in favor of the gentlelady's motion signify by raising your hand. All opposed? And the motion is defeated. Thank you for your time, Senator. Understood. Thank you, Mr. Atwood. I think we still have a quorum. 1, 2, 3. Barely. Senator Davis, let's see if we can do this and still keep a quorum. We do have a substitute in your folders. I believe it's LC 296036S. Senator Davis, do you have that?
I do have that.
Okay, I just want to make sure that we're all on the same page on that.
Thank you, Mr. Chairman, members of the committee. I appreciate your time this afternoon. I present to you by substitute Senate Bill 383. Over the last several years, there have been a number of incidents involving coroners and or deputy coroners and medical examiners, whereby current statute, there's a perceived loophole. We've taken steps to try to address that. The more recent incidents have happened in Augusta, Richmond County, where a deputy coroner and the coroner of record took personal property off of the deceased individuals and possessed it as their own. I think we would all agree that we shouldn't be taking stuff from dead people. In Section 1, lines 23, we've added language that we believe clarifies the current statute by mandating or stating that under no circumstances shall any property of value found on or belonging to the deceased be converted to personal use of the coroner or county medical examiner. In the subcommittee meeting, we received input and testimony from the members of the committee at the time, and in lines 33 through 37, we believe a worthy amendment, which is why we have the substitute before us today, that adds language that any coroner who converts property of deceased to his or her personal use shall be guilty of a violation of the said code section. I believe that's an appropriate amendment, certainly one that I'm supportive of, and I'll be happy to take questions from the committee.
So the coroner converts the property of a deceased to his or her personal use, guilty of theft by conversion upon conviction shall be punished as provided in 1618-12, which is
The theft, and it's a higher penalty when you have a fiduciary duty.
okay.
1 to 15.
1 to 15. Questions for the author, Mr. Pack, who's also, I think, the subcommittee chair, if you want to give a report at the same time.
Thank you, Mr. Chairman. I think during the subcommittee there were concerns raised by some of the members that without the penalty provision being enhanced, because the coroner is responsible for actually inventorying the items, that there's not enough of a deterrent for that person to, they could convert the theft by not writing in the inventory of the items found on the deceased. As a result, we want to enhance the penalties and reference that this is actually a serious, more serious theft because of that fiduciary duty we have. As a result, we suggested language, and this language came from the Prosecuting Attorney's Council, and the chairman was gracious enough to adopt the language.
Yeah, that is a strengthening amendment, and given the circumstances, one would want to have an enhanced penalty provision.
Absolutely, I concur with that. I had no issues with that whatsoever.
Great. Questions for the author? Seeing none, there's no one signed up. Is there anyone who is here to speak for or against House Bill, Senate Bill 383? Seeing none, what's the pleasure of the committee? Mr. Ramsey moves due pass of Senate Bill 383 by substitute LC 296036S. Second by Mr. Pack. Are there any amendments? Seeing none, any further discussion? Seeing none, all in favor of the gentleman's motion signify by saying aye. Opposed? The ayes have it. The motion is adopted. Thank you, Ms. Senator Davis.
Thank you, Mr. Chairman, members of the committee. There was a time where I sat next to you.
Yep. I remember, not too long ago.
That's right. Today I sit in front of you for the last time. I
Good
appreciate
luck.
it. Thank you.
Very best of luck to you.
Thank you.
And we're adjourned. Thank you, members of the committee.